folks, I am going to, what happened was, we were asked to do a legislative panel. And I said, well, I was asked, and I said, well, if you're going to have me do that, then I need to pull in Robert Garza. So I've already done my amazing program already. I'm going to let Robert do most of the talking today because he has taken my starting point, and he has really done a beautiful job fine-tuning and cleaning up stuff. So, title to our program, Family Law Reform Legislation, Comprehensive Child Protection and Family Justice Acts. We want to and need to make sure we have legislative things in place that are going to protect the children. And in protecting the children, we will also be protecting the parents, whether it's the alienated parent or the targeted parent, or alienator or target, because there will be laws in there that will protect everybody. Okay. Yeah. Oh, they're closing it. So, as I said, we're protecting children and ensuring justice in the family courts. Because as we all know, we have a big issue with what is going on in the family courts and not having our rights and due process rights recognized and respected. So, when Robert and I began this, we began to realize that as I had done stuff in October with the PA Consortium, that we had a lot of overlap. So we have core legislative framework with 6 acts, accountability. So this is from the consortium. And then we found that Robert's stuff and his 13 complementary reforms kind of parallels a lot of what we were doing. And that is kind of how I'm coming at this and why I am letting Robert do most of the speaking today. Don't get me wrong, I love to educate. So at the conference, we came up with accountability for false allegations. Robert's got one, some here, 3 strikes law. You've got Shared Parenting Act, Robert's got that. Child Testimony Protection Act. This was something where we had children who were telling us that they were forced to testify, but they had to lie. And when they finally got up on the witness stand and had their voice, they were able to tell their story and not have to lie. Court standards of parental fitness. We are not getting due process rights of an evidentiary hearing where we're adjudicated as a fit parent, but yet our rights are being taken without formally being taken. Okay? Court custody interference. With this in the U.S. is a felony in every single state. Other countries may call it parental kidnapping. Others may call it just regular kidnapping, but it is illegal. Post-appeal judicial reassignment. What this means is, we're talking about that when you go to appeal, that the case doesn't, and you win at appellate level, that it doesn't go back to the same judge you were just with, who already doesn't want to know anything about your case and is already going to side against you no matter how many times you appeal. Robert, I'm going to have you go through your 13. Sure. And actually, I don't need a microphone.
So, my name's Robert Garza. I went through family court for about 16 years, spent about $700,000 just to be able to be in my children's life. I have joint custody. They were never able to take it from me. All the allegations were false, about 43 plus, and they were all done by proxy. So my ex never came to court and said I did anything wrong to my child. She went to mandatory reporters. They reported it to CPS because they were mandated to. And then she would go get that open case number and run to family court and get a protective order, restraining order. This is why I couldn't share my story before, because there was nothing that could be done to stop this, and it would weaponize the system like crazy if people found out. So I came up with time taken, time back. And so every time that I went to court and asked the judge to give me my time back after the allegation was ruled out, the judge never did. This happened 43 times. And because of it, went to my legislator, Angela Paxton, came up with time taken, time back, and what it is whenever somebody goes through a false allegation, and that allegation's been investigated, it's been ruled out, there was no abuse or neglect found, then you take it to court and you get a what's it called, you file to dissolve the protective order restraining order, and in doing so, after this is implemented, it went into Texas, so when you return the child, you shall return the time. And what it does is, it disincentivizes making a false allegation, but it doesn't disincentivize making a real allegation. And it's the same type of time and the same exact amount of time. And so, if they hijack your Christmas, then you get 2 Christmases in a row. If they hijack your spring break, you get 2 spring breaks in a row. And this is where the alienator usually takes your time. Right before the kid's going on spring break or Christmas, there's lines going into the courtroom, taking your time. If there was real abuse, there was several days before that they could have taken your time, but they do it at the last minute, so your holiday's taken. So the time taken, time back is a very pretty bill. It went through unanimous, bipartisan the first time, and the governor signed off on it on Father's Day. And so after that, I had other advocates reaching out saying, hey, we need this in our state. And so I amended it for North Dakota. And when we did it for North Dakota, it was amazing because the senators and House reps were like, well, we need to reprimand the alienator somehow. And I was like, well, they'll never pass it if you do that. And so what we ended up doing was doing double the time back at that point. And so now it really disincentivizes doing a false allegation anymore. And so once I did that, I was like, okay, we need to amend these laws for every state. So as of today, it took about 6 months to do, but I've amended about 450 laws. And let me tell you, it has been, I can't even tell you, the learning curve to amend a law. I had to learn civil law, criminal law, constitutional law, just to be able to defend myself in family court. I'm pro se. Now my ex kind of leaves me alone. In family court you can resue for whatever it is that if you don't like what you got, you can resue. That's the sad part about family court. And so now I ended up coming out with more bills for every state because I saw all of the legal loopholes that they played against me. So when we did the time taken, time back, I closed that loophole. Now, when I did that, my ex stopped making false allegations and she started interfering with my child custody. I'm like, you gotta be kidding me. I had to change the law and now you're still gonna play games? So then I had to come up with something that stopped the interference with child custody. And I know most of you have done this before, if you've been through this. So when somebody interferes with your child custody, you call the cops, they come out, they tell you it's a civil matter. It's not a civil matter. It's a criminal matter in every state. In fact, it's a state jail felony in most states when they interfere with that. But the cops tell you it's a civil matter just because they don't want to mess with it because they don't want to arrest a parent the first time that this happens. So went to talk to all my prosecutors and DAs in quite a few states and figured out that if there was a better way, they would prosecute for it. And so what I came up with was amending the current statute, and this is a criminal code that I'm amending in every state. And so what it's doing is I'm making a state jail felony, what it is right now if you interfere, to 2 misdemeanors before the felony. And what that does is it makes it where a cop can come out and actually give a criminal fine of $500 for someone that's interfering. They're not going to rip the child away. They're like, hey, are you going to give the child, to the other parent? Here's a court order. They say no, no problem. Here's a ticket. Now, it's amazing for protective parents that if there is really something going on, then that gives that protective parent a way, instead of getting arrested, what they should have been doing right now as the law reads, if they do what the law says. And so they can take that child to CPS, to a counselor, get something done. Now, you can take that fine of $500 to a criminal court, this is not family court, and you can get it dismissed if that's what the issue is. And so this is a new way of looking at it, and so now, if people are withholding, they're not gonna be withholding or playing games anymore. So they know when the cops come out, someone's gonna get that $500 fine. And it incentivizes cops to come out, or police, because that 500 fine goes to that municipality that comes out. Right now, your states are being drained of funds, and your cities, because just in Texas alone, there's a city, San Antonio, Texas. They get over 1,000 interference with child custody calls a month. Just on that alone, there's 1,200 cities, multiply that, that's 1.2 million calls a month for interference that they don't have anything that they can use. This is the new tool that they can use, and the only tool that the police force has, and this will stop the bad behavior. Now, go ahead.
Well, just to clarify, I don't know if it's, you do not have a background in law or as a police officer that you did this all on.
Correct. I'm just a parent. I am just a parent that went through family court and lived all of the legal battles. So when you say attorneys go in there, they practice law. You're living what they're practicing every day. It is your freedom that is at risk, it is your child at risk, it's your children, and those consequences you're gonna have to live with, and so is your children.
We kind of used to joke, one of my clients, that we've had to learn so much about the courts, the family courts, that we want to sit for the bar.
Yeah. So what I
I
found.
passed.
Yeah. So I have a $700,000 degree in family court. And 16 years. So I think I've been living this longer than a lot of people have been practicing. But in doing so and going through this, I learned what needed to be changed in the law to tweak those things for the system to work like, I wouldn't say it was meant to, because it's probably working like it was meant to, but we're gonna make it work for the people, by the people. Dr. Warren Farrell had a quote, and he said that the current system, or the family court system in its present form, is, what did he say? Anyway, it's basically the worst that there could have been no other system designed to hurt the family more than the family court system in its present form. That is an amazing statement, and it's true. But after looking at it and you've seen these bills will fix every bit of it. And it'll tweak the system to where families won't be playing the games that they're playing. The problem is right now, perjury is a felony in most states right now. The problem is family courts don't prosecute for it. I've looked in all 50 states, and there hasn't been one that I've found in 15 years in family court. They do it in criminal court, but not family court. This is the problem that we're seeing, and the lawyers that are teaching their litigants how to play these games. This needs to stop. And knowing that, so I came out with a couple of things. So time taken, time back is when you make a false allegation, when you return the child, you shall return the time. A new start at equality, that's 50-50. Most states do not have 50-50 right now because they're trying to amend too much at the same time. You have, like in Texas, people are submitting these 23-page bills for a legislator to amend 50-50 custody. That will never be, because nobody wants to amend that much law at the same time. If you see my new start at equality, all you have to do is be fit, willing, and able, and live within about 25 miles of your child's school. That gets you over the threshold. I always tell people you have to look at this like it's like a civil rights movement. If you are going to abolish slavery, they just did that. They abolished slavery. They didn't put in there that you could be president, that you'll have equal rights, voting, marry the opposite color, any of that stuff. Had they done that, that never would have been. So this is the new start of equality, just to get you over that threshold. The sad part is that judges have the opportunity right now to do the right thing. They could give 50-50 in any state. They just choose not to. They give you the lowest standard of possession, which is 29% to one parent and the rest to the other. I have a huge problem with that. And here's the thing with, I think it's an educational thing. Because if they really knew, and I hope that they wouldn't do this after they knew, when possession falls below 40% to any parent, you're putting that child at risk for alcoholism, teen pregnancy, high school dropout, incarceration. With those rates, our judicial system with standard possession has been sentencing our children to be at risk for the last 50 years, and that's the problems that we're seeing right now in family court and with our children. That's why you see all these behavioral issues and confusion on who they are or what they are. If we put families back and nuclear families back into the system and disincentivize divorce and disincentivize conflict, then this will solve all of our issues very quickly, and we will see a massive change in the way our communities work, our children, and our relationships with each other. Because this is a generational thing. Hurt people are hurting others, and it just keeps continuing. I'm glad that we're here at the PASG, but I went to a lot of these conferences, and I keep hearing the same echo chamber of the same things. They see the problems, but there's no solutions that I've seen that anyone's offering. So these two things will put families back together. The 3 strikes, I already talked about that one. That's where the $500 fine is, so people will stop the bad behavior. And it gives a track record for district attorney's offices to show that that parent's making bad choices. So justice for targeted parents, reimbursement of fees and costs. That one is amazing because when you're going through family court, that one, when this bill goes through, if there's alienating behaviors in family court, and I'm not talking about alienation, but alienating behavior, so interference with child custody, if you're gatekeeping, if you're bad-mouthing, false allegations, all of these are alienating behaviors. If I was doing that to my ex and this law was enacted, then the judge would, well, they wouldn't have any choice. If these were found, then I would have to pay not only my attorney's fees, their attorney's fees, and all the professionals, if alienating behaviors are found. Now, at that point, who taught me how to do this? My attorney more than likely did, because people just don't come up with these things. So I'm gonna point to my attorney and say, hey, my attorney's the one that taught me. They're gonna stop with that bad behavior and teaching litigants how to do this, because then their bar cards are gonna be at risk for teaching the litigants how to do this. And if litigants do know how to do this and they're narcissists and whatever else, then they're gonna stop doing that if they're gonna have to pay the fees if this stuff continues. So that's another one. Dual child support. It's just a recalculation on child support. Instead of taking one parent's income, you take both, and then the time, so it's just a different calculation. Justice delayed, justice denied. That's another one I didn't think I had to come up with, but I did. So after I came up with the time taken, time back, and then my ex did it again with interference with child custody, we got into court because I filed in criminal court and in family court. So I filed an enforcement in family court. It took 6 months to get into family court, about $3,000 to $5,000 to give my attorney a retainer to file for enforcement. The problem with my case is that the law firm that my ex hired helped the judge get elected, and that's why this became, and that's why it took 6 months to get in there because of all the games. But then after we got in there and I proved that she did interference, it took 6 months for the judge to rule. But I didn't know that it was gonna take 6 months for the judge to rule. So after about 2 months, I'm like, hey, what's going on here? And I started investigating all the states. Surprisingly enough, in every state pretty much, except for about 2 or 3 right now, judges don't have a time limit. We all have time limits on how to put evidence in or anything else. Judges do not have to rule. There is no, they rule, but there's no thing telling them that they have a time limit to rule.
They have something, some of them have
Some
a
of them.
little something
Right.
that says, well, they've got 120 days, but it doesn't mean they have to do it in 120 days.
Right. It's a suggestion in some, in
That's
some
the
of them.
word.
And so, and this leads to another problem, is where you can't hold judges accountable for not ruling because it's not in stone. And so if you try to turn them into the state bar or anything else, they have discretion because it's not in stone. So the justice delayed, justice denied gives them a 10-day rule. In any family court setting, doesn't matter if it's on a protective order, restraining order, or anything, they have 10 days to rule after any hearing or trial. And so this holds them accountable. And then, I didn't wanna take the discretion away, but I'm giving them more accountability. So in this same bill, you'll see that if they need more days and someone said, hey, we need a drug test, it says in the bill that they have 7 days after they get whatever they needed to rule on. And then even after that, if they need 10 more days, they have to write into the case why they need 10 more days and that they need 10 more days. So it gives them more accountability to just hurry up and rule. Now on that one, I have judges ready to testify. I have attorneys saying that judges already say that they run their courtrooms, that they don't wait more than 7 days because they're human. They cannot, they can't think this way. That's not justice. So what did you have for dinner last Thursday? You don't know, and you only had 3 meals in between. A judge hears 10 to 15 cases, the same type of cases, every day. They can't possibly remember all the little nuances of your case. This is not justice, especially if you're paying $10,000 to $20,000 or $100,000 to get in there for a trial, and then they wait 50 to 100 days to rule, that they can't even remember the facts. That is not justice. So justice delayed, justice denied. Cameras in the courtroom. We have Zoom calls, all that stuff all the time. There's already cameras in there. This is to be recorded. This is only for the litigants. That way, if there's any crazy stuff going on, like a football game, rewind the cameras. Temporary orders appealable. This is huge. Most people's temporary orders in every state are not appealable right now. Your temporary orders are your final orders unless you can get into final trial. The judge gets it wrong, you're hosed. If you look up this, and all of these bills that I'm doing are one-pagers. Very short, concise, to the point. They're on robertgarza.us. You can literally hit the bill. I've amended them for your state, and you can see the legislative pack. Super easy to read, and has the background for the bill, why the bill's needed, and it even has, if you want to just copy paste a thing to your legislator, and we can zoom in on the call and get this in your state. Litigant access and economy bill, that's, again, Zoom. Right now, a friend of mine he's a lawyer. He was telling me he had to charge his client, $1,200 for a 2-minute hearing. I was like, well, why'd you do that? Why didn't you just zoom in? He was like, oh, it doesn't work like that in Texas. You have to ask the judge for access and they can choose to not let you do it or do it. So when you read this bill, it's really short and concise. Basically, it's allowed if there's technology that allows for it, and the judge, if they don't want you there, or if they want you there in person, then they have to basically tell you, yes, you need to come. And so this would have saved that person about $1,200. The other thing it does, if you're living paycheck to paycheck, which most of us are, then you can stay at work and just zoom in and not have to miss work at all. You just walk outside, have your hearing or whatever, and it's gonna save lawyers a ton of time too. They can take these calls and and they can get a lot of work done instead of being on the road going to these hearings all the time. The mandatory transcripts, I've had to pay $1,500 to $2,000 for, even after paying my attorneys, to get a transcript just to write the order. That's crazy. So this is for indigent litigants right now, and that's mandatory transcripts that you can get that for yourself and for appeals.
The only other way around the indigent is if you are legally disabled, you can request free transcripts under ADA accommodations. That's something we can discuss at another time, but that's the only other way around it.
Yeah. Role for limitations of guardians ad litems. In Texas, if you're a guardian ad litem, you don't have to be an attorney. You just take a course and all of a sudden you can make all these decisions for kids and custody and everything else. In Texas, we have a thing called a home study, and guardian ad litems aren't supposed to make any kind of decisions when it comes to your parental possession. They do anyway because they're usually friends of the judge, and the judge is the ones appointing all these. That's another problem, but if you read the bill, it takes care of a lot of that other stuff.
Connecticut is probably about the only state that in January 9th, 2014, we got a task force to put oversight on the GALs. They were originally, I had known of clients with over $500,000 in bills to guardian ad litems, put oversight, that stopped. But unfortunately, the GALs in our state are 95% all attorneys. GALs really need to be mental health professionals, not attorneys.
So Family Court Fairness Act, this one's actually a really neat one. So most people weaponize criminal court when they get a divorce or anything like that. They try to do crazy stuff in criminal court so it affects you in family court. This Family Court Fairness Act, unless you're prosecuted for whatever you're accused of in criminal court, they cannot bring it into family court anymore. That stops the bad behavior. Now, if has to do with, like, let's just say a DWI, I get it. And so in this is also written there, if it's something like that, you can bring it into a separate hearing to see if it can come in. But it just doesn't automatically come in unless you're prosecuted for it, so.
You have to be convicted.
Correct.
A conviction in order to bring
Correct.
it into the family court. You can't just have it rolling around in criminal court with and use it.
Yeah. And then the Due Process Restoration Act, that one's a neat one too, because right now, if you're accused of something, and they get that protection order, restraining order, or whatever else, then when you go and dissolve that protective order, restraining order, it's still on your record. When it gets dissolved, it doesn't automatically come off your record, but after this passes, it will automatically come off your record. You don't have to do anything else, so when it's dissolved, this will save a lot of people because they keep bringing it back and re-weaponizing it like it's a new whatever, and it's not, so.
Most of the rest of our slides may be repetitive, so you may see me go click, 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 click. Okay, this was just about the PA Consortium and the work we did in October of last year, where we sat down and made up 6 pieces of legislation that we then tried to shrink down as much as we could because, as Robert said, his bills are 1 page. Why? What's the old saying? Simple, stupid. We get their attention simply so that they can focus on what is really the first step in everything that has to get done. So I'm not even going to read most of this because Robert has really pretty much presented most of what's here. The most important thing, the core principle, children's well-being is best served through relationships with both fit parents. An unfit parent doesn't mean they can't be a parent. It means they need the support services in order to learn how to be and to become a fit parent. Can all parents that are unfit become fit? Not necessarily. This comes from their background of how they themselves were raised. 99% of alienators were victims of abuse when they were growing up. They are projecting what happened to them through the children onto the other parent in an attempt to save little them. They have no understanding of the borders and boundaries between their life experience and their children's. I call it borderless boundaries. Again, Robert Garza's 13 bills. This is where we discuss the false allegations and the remedies and things that can go on. So when we did it at the PA Consortium, criminal liability for false malicious allegations, that's actually a U.S. code, parallels to a U.S. code 18 U.S.C. 1038. Civil remedies, including defamation actions and compensatory damages for doing this harm. No statute of limitations with retroactive cause. Statute of limitations means many things that go on or that we want to sue for, or that we want to have adjudicated, have a time period within which you must bring them forward. Statute of limitations, or SOL, or also nicknamed shit out of luck. Mandatory counseling for those found guilty. You've done something. You need to be in therapeutic supervised visitation as well, let alone proper therapy. Not with somebody who's just getting their license and doesn't know what they're doing. Somebody who's specifically trained. Prosecution for genuine victims while distinguishing from malicious claims. Protection, We need to protect our victims because they're traumatized from the false allegations. It causes PTSD, stress, anxiety. I'm sorry, I don't care who you are. If you're an alienated parent, there is no way you're going to convince me that you do not have PTSD, stress, or anxiety at some level. You just cannot not have it. Robert, anything here? Robert's talked about the time taken back. False allegations, intentional or lacking factual basis. False information and hoaxes. child psychological abuse. Connecticut is the only state I think that I know of that got the governor to sign the proclamation for September 9th for International Falsely Accused Awareness Day. This is something you guys can all do next year. And asking your governors, your senators, whoever it is proclaims in your state or country to proclaim September 9th International Falsely Accused Awareness Day. Because guess what? It's not just in parental alienation. We see it in many other areas as well. Shared parenting. We kind of discussed all of this. I don't know, Robert, anything here you see that we need to rehash?
No.
Anybody have a question on this slide before I go click, click? Go ahead, Larry.
Robert, are you working with Don Cuban with this, with shared parenting stuff? And you guys building and having a reciprocal arrangement?
Explain it, John.
Yeah, so,
Let me just, Don
No, you
Huber is
answered
the
my
president
question.
of the
Yes.
National Parents Organization.
yeah, so they're passing shared parenting in a lot of states, and they have stuff written. But there again, we need to,
You have
A
a
lot-
simplified version?
yeah, I have a simplified version, so we're gonna put both through. So they're gonna put the, not them, but, whoever's gonna put their own versions of shared parenting in, and I'm gonna put my simplified version in to get it over the threshold. And so whoever the legislators pass, they pass. At least we have one with all the teeth in it, and then we have one that gets us over that threshold, that gets us to where the judges are automatically at equality.
And I'm going to point out a couple things here. The key features: rebuttable presumption that equal shared parenting serves best interests of the children, equal decision-making authority, and approximately equal physical custody time. Remember, sometimes there might be a parent who lives a little bit too far, or they work and travel, and so that might limit a little bit, but that would be no different than if this was what I call an intact family. If this was an intact family, would we be removing custody because the parent has to work more and isn't as around as much? No, we would not. And clear and convincing evidence required to deviate from any equal time. Clear and convincing is what we use in the criminal courts. Many family courts do not use clear and convincing. They use preponderance of the evidence, which means, oh, there's a 51% chance that maybe this is going on. That's not enough.
They're like, it's more true than less true. And when you're dealing with families and children, that shouldn't be that low standard. You can't take away a parental right unless it's clear and convincing. I have a bill, it's not on here, but the last bill that I wrote was to take that preponderance of evidence and heighten it to clear and convincing for everything. That way, that alleviates, if you make a false allegation, judge is gonna say, okay, you have to prove it now. If they get up there and do perjury on the stand, it's like, now prove it. There's no more, it sounds more less true than true. And so we're still looking at that and the repercussions of, because I don't want to pass legislation to make something worse. I want to always make it better. And so that's what you have to be careful when you're passing legislation like this. Now, all the other bills I have been researched to death. And there is really no downside to any of them on anything else. But that one, I'm still working and looking at judges and attorneys to help me understand and what their thoughts are on that. So, but it makes sense to take that standard and heighten it. That way, it doesn't matter if you make a false allegation, now you have to prove it.
And as you can see from our slide also, we're trying to ensure that the courts prioritize equal parenting time, promoting fairness in custody. But look, we've got grounds for rebuttal. Look what comes up back at us. Domestic violence or child abuse. Well, prove it. Please, provide the courts with solid, verifiable evidence if you're going to claim domestic violence or child abuse. Robert, 43 times was accused of abuse. That is excessive and ridiculous. Parental fitness. They're going to claim, oh, well, they're not fit. No. Logistical challenges. No, we can work around logistical issues. Courts must provide written findings for any deviation because otherwise they can do anything they want.
So let me tell you about this one. So I just had a senator in Arizona say, hey, we have shared parenting, but it's not working. I was like, I bet you don't have findings for facts and conclusions of law built in. She was like, we don't. And I'm like, that's exactly why. Because a judge can deviate, but not have to write why they did it. When you make the judges more accountable and actually write the findings, facts, and conclusions of law, more than likely they won't be deviating, because now they have to have clear and convincing evidence. That is the game changer right there.
With some additional provisions, friendly parent consideration. Is there a friendly parent who's the one that's being adversarial here? Sanctions for undermining shared custody, hostile aggressive parenting, whatever you want to call it, I don't really care. Or somebody impeding with your right to shared parenting. And there should be annual court reporting requirements so that we know what's going on. How many families are losing custody? How many families are having it impeded with? Any questions on this slide? Go ahead.
So, it's just an observation from my personal case is like an alienator also has a team behind them, like the in-laws. Like, is there any way where the in-laws could be fined too?
That's a good question.
Here's the thing with that. I know, believe me, I was the first one that wanted to, like, have my accuser,
Held accountable?
yeah. But when I did the taken time back, I made it such a pretty bill that it couldn't be argued against. So when you return the child, you shall return the time, the same type of time. It didn't stop someone from making an allegation, but it disincentivized making the real allegation. The other thing I could have done in my bill is make it retroactive. So I could get my time back with my children, 2.5, 3 years that I lost. But I didn't do it because it would have stopped up the court system. All of these bills that I'm doing aren't to make the system worse or to be for my benefit. They're made to make the system work cleaner, more efficient, more accountable, and more transparent.
Now I'm gonna move on because we're running out of time. We know, look, just so you know, we have another time slot at 2:15 because we were concerned there would be a lot of questions and people needing more info. We will be back in this room at 2:15, okay?
For Q&A only?
Q&A, and if we don't get through the whole thing here,
Nice.
okay? Child Custody Protection Act, this was, child testimony rather, that's because, like I said, court protection, prohibition on direct child testimony in custody proceedings, because why? The alienator will call the child to the stand, poor child knows the truth but can't say the truth, and because the alienator is sitting right there, so they have to lie. Well, now they've got a guilt complex for it. Children may only provide information through qualified professionals. This is part of what we would like. Video recorded forensic interviews in child-friendly settings, because we need to know, is this child being influenced by the evaluator? Pre-approved open-ended questions only. In other words, open-ended, not a yes, no, because we're getting kids who are being prompted for answers. Professional requirements. Must have an advanced training in psychology or psychiatry. Specialized training in child development and family dynamics. Forensic evaluation certificate. Expertise in custodial interference assessment. Because otherwise we're getting evaluators who don't know what they're doing and they're missing so many red flags. Safeguards. Sealed evaluation records. Trauma-informed counseling access and protection from retaliation. Your therapists do not have immunity. And so we're getting slammed.
I have a question with that slide.
Go ahead.
Because in New York, we have in camera, the child does not take the stand. Is there, in this court, the child actually takes the stand?
There are many, more and more judges are not allowing it. Historically, they have allowed the kids to get up on the stand. We are still seeing children being put on the stand to testify.
It's very rare in New York, but I'm just.
Because of the psychological trauma to the child.
Okay.
Child court standards for parental fitness. You can't, okay, in order to determine a parent's fitness, there must be some kind of a hearing. In the United States, we call it an evidentiary hearing. Without an evidentiary hearing to prove your fitness, your due process constitutional rights are violated. So it must be, as I said, adjudicated through evidentiary hearing and psychological evaluation based on either inability to provide basic needs and safety. If a parent cannot take care of their child, of course that's a problem. Ongoing addiction impairing parenting ability, history of abuse and neglect, mental illness significantly impairing parenting. You can't say just because somebody's got PTSD, stress, and anxiety that they can't parent. If we did that, most kids would not have a parent today, especially after COVID.
Especially after going through the family court.
Yes, I was gonna say
Thank
that.
you.
That gives you PTSD right there.
And then it gives the kids PTSD, and are they not good enough to parent when they get older either?
Right. Deliberate abandonment without valid cause. So you walk away from your kids without a valid cause. A valid cause could be that you're being so horrifically attacked, you can't manage it anymore, you don't have the financial means, and you're feeling like your child is being pummeled so badly that they're gonna end up with a psychiatric back break. That could be grounds for abandonment, and it's not abandonment, it's grounds for taking a step back or to the side. Assessment procedures, psychological evaluation by qualified professional, not an attorney. I'm sorry, attorneys, you're not trained in mental health except for Desmanos Lorandos, who has both a law degree in psychology, very rare. Evidentiary hearing within 30 days. Not just 6 months and you haven't seen your kid and now it's 6 years and the kid doesn't want to have anything to do with you. Monthly review for deemed unfit parents. With those parents that are deemed unfit, we need to review. Have they gotten it right? Have they been in therapeutic treatment? Are they getting better? Remember, these people their role model was their parents. So how would they know any differently how to raise their child unless somebody's teaching them another way? They actually lack executive functioning skills because they don't know. I could go into that for hours. 30-day maximum evaluation timeline. None of this 90 days, 6 years. No. Protections. Religious preferences cannot determine fitness. A child can learn from many different religions. Okay, you don't need one or the other. I actually got yelled at in my Hebrew class because I'm not a really good Jew. And when they told me I had to believe in the Jewish God, I said, why do I have to believe in the Jewish God? Isn't there any other ones out there? Let's just say, they weren't too happy with me. Parenting style, variations, not evidence of unfitness. In other words, just because you don't make gourmet meals doesn't mean you're not a good parent. Just because you don't know how to make scrambled eggs the way the child wants them doesn't make you an unfit parent. Because we've seen that. Well, you don't know how to make scrambled eggs. Answer from the parent, oh, can you show me how you like your scrambled eggs made? Stop. Child's view, not a factor in fitness determination because the child's view has been corrupted. Custody Interference Prevention Act. Custodial interference, as we stated, it's a felony. So we've got legislative findings, parent-child relationship, loss presents greater risk to a child's well-being. We all know this already. Custodial interference causes significant psychological harm. There are 5 categories that my group did on psychological abuse. Custodial interference and the harm is in there. Intentional manipulation constitutes severe family violence and child abuse. Types of interference: direct, physically you're right there pulling that kid and not letting him. Indirect, preventing communication. Or literally, the child says, oh, when I was at daddy's house or mommy's house, I did blah, blah, and the parent turns around and walks out of the room. That's indirect. You're kind of not, it's subtle. The parent rolls their eyes. Key provisions: recognized as a criminal act, heard in criminal court, not in family court. Our family courts are civil courts. They cannot really adjudicate on a criminal matter. Mandatory 20-hour high conflict management classes. 3 strikes penalty program. No statute of limitations for filing. I'm going to move on here because we're only at slide 11 of 30. It wasn't even a long presentation. Yeah, so do all of you guys want to come back at 2:15?
Sure.
Because we can extend over because we're now at 1 o'clock, it is lunchtime.
We don't want to run into their lunch.
Right, we don't want to run into your lunch. We will stop here, okay? Remember slide, what did I say, 11? And it's not that there's a lot of slides here, it's the amount of information that we have to give you.
So we We can reconvene after lunch. I can tell you that in Texas, we passed another law which went into effect also. It's called a 3 strikes for the civil penalty. And so this is 3 strikes for the criminal penalty. And that one went into effect September 1st, 2025, this session. So when you have 3 contempts of court, the judge has no more discretion in Texas. It's automatic jail time. Where they have discretion is how much jail time that they get. But now, because we've had people get in there and get 20 of these things and judges don't do anything. So now because of that, they had the opportunity to do what they should have done, they didn't do it. So now we made a law to do that. And then the other one that we did was the SCJC, it's who you complain to if the judge is not doing their job. And they can reprimand them, they can sanction them, all kinds of things. The SCJC in Texas wasn't doing their job, and so what we did is we made a law that said that we put 7 citizens on that judiciary committee to watch over them and be part of it. That is changing on a massive level. So every time that we see the legal loopholes that they play, we're shutting them down with legislation, with the legislative branch that controls the judicial laws.
Can I say something on that, Robert? That's a huge point. I'm an attorney in Arkansas. My name's Kevin Hickey. On the third
Represented John Mast.
Yeah, I represented John Mast. You know the John Mast story. For the non-lawyers, if you're gonna try to get some of this legislation implemented in your state, you've got to use that word shall. Judges need to see that word shall on that, it's the 3rd strike, right, Robert?
Yep, yep.
So they get a couple of freebies, they still gotta pay, but they get a couple of freebies, right? That 3rd one though, when that judge has no discretion to not do something. They have to do whatever that says, so you've gotta make sure that word shall is in there, cause that's where you're gonna get some pushback from representatives or whatever. Fight for that word, because then the judge has no discretion. They shall do it. They have to. I just wanted to point that out.
Yes.
I'm a commissioner from British Columbia, Canada, and judges often don't enforce orders. So with the new legislation, if a judge does not follow legislation, is there accountability and consequences
Judicial
for the
accountability.
judge?
Yes, and that's the panel that I was telling you about, the SCJC.
Okay.
But the problem that everyone's having right now, you think the judge is just doing the wrong thing. They actually have discretion to do what they're doing, because the law doesn't tell them they shall do something. Right now.
Says they can.
That's
Yeah.
why that's so important, because a judge, if they can, I'm sorry.
No, you're good.
No, you're good.
If you're backing away, or if they have a way out, or whatever, they're gonna take it, because they don't wanna put people in jail, they're hearing it from the sheriff at the county jail, we got too many people here. That's why you gotta have that shall in there, then they have no discretion to avoid it.
Spread the word that we will be back in here at 2:15 so that people that want to know more and need to ask more questions, we will be here. Kevin, are you gonna be back at 2:15?
I'm gonna try.
If he's back, we'll
So when we come back, I can explain to you and show you where the new bills, like how I worded them and why we put the words in that are so important, that give it so much teeth. And I'm telling you, it's gonna make a world of difference. Come November, December, all of the bills that you see here are gonna go into pretty much every state. We're amending them for Canada, Australia, a bunch of other countries right now too. Like, these bills are gonna sweep the nation, and it's gonna give more accountability to the court system, where they still have discretion, but if they go past that discretion, kind of like the findings of facts and conclusions, if they want to do something else, it's going to give you a very clear black and white thing to turn into the SCJC to reprimand the judge for not doing their job. Because right now, it's not black and white, it's gray.
So how, Joe, go ahead.
More of a comment. So I'm an attorney from New York. Joan mentioned that you had like 43 frivolous petitions filed against you or something like that.
Yes.
In New York, we have a case, and maybe this could be a bill. It's called Shreve, S-H-R-E-V-E. And what that case says is you can file a motion with the judge to prevent the side from filing frivolous petitions.
Yeah, it's a vexatious litigant act.
Yeah.
But think about this. The court did it on a precaution, because my ex was able to take that open CPS investigation number, take it to the court, say, we need an emergency protective order, restraining order. that judge has no idea of what's going on. It's an emergency. And so as long as there's an open CPS case, that judge, and they can shop it around. It was never the same judge. They were not stupid. They went to visiting judges and whatever else. People didn't know what was going on or seen my case because of that.
Yeah, New
And
York,
so-
the street goes right up on the computer.
Yeah, so that was the issue, but it's getting better now. Like I'm saying, like, you know, there was a reason that I went through it and people like you are going through it because the family courts are breeding advocates. And now you know more, way more, education-wise because of social media. This is the tipping point, I think, where it's going to make more laws fair because of the education that everybody's getting, so. Yep.
Thank you, guys. We're continuing on from where we left off in the slides, but trying to hope that we're gonna leave enough time for some extra Q&A because we were answering questions as we were going along. Wait a minute, I don't need a microphone. Here, Robert.
Thanks.
So, when we left off at this morning, we were at enforcement penalties framework. So basically, you have monetary fines, we have imprisonment for substantial harm cases, you know, where there's actually documented harm from what is going on here. Enhanced penalties for deprivation of these acts, okay? Criminal record documentation. That these people who are causing these criminal acts, we want this documented so that it can be properly adjudicated. Civil remedies. You have defamation actions. Most courts don't usually take them. You cannot bring them into the family court. Family court cannot adjudicate on a lot of these things. Compensatory damages. Robert has talked about this, that compensation for all the money you have spent trying to defend yourself. Legal expense coverage, you got that back again. Punitive damages for egregious conduct. When you have attorneys that are misbehaving like this, well, we need to have them held accountable. I can't tell you how many attorneys hint to their client, oh, you know, did he put a hand on you? Oh, you know, that's no, it's not abuse. Oh, did she put something? No, that's not abuse. Okay? Graduated penalties. Now, under mine and under Robert's, we have different things. It's $200 fine, 5 days community service. This was one of my programs with 3 strikes, you're out. This is a program I created that only lasts for 12 weeks and 3 chances for a parent to comply. It pairs phenomenally with Robert's 3-strike policy. His is legislation, mine is to be used in the courts. So I say, but what if this parent has a lot of money? My program's tailored to fit the case needs. So instead of $200, maybe it's $2,000. They have 5 days of community service and 5 extra days of visitation for the targeted parent. Second strike triplicated. In this case, 200 becomes 600. But if they're charged 2,000, now it's 6,000. 15 days of community service with who? Community service with kids that have no parents because of a death or whatever. We need this parent to understand the gravity of not having their parents in their lives. Third strike, $1,800, triplicated. Everything's triplicated, and 45 days. Okay, and potential loss of custody. Robert, do you have anything to weigh in on this? It compares with his policy. Robert's.
So on mine's civil, it's, I'm changing the law for family court. And what this does, well, I'm sorry, this is criminal. So this is the criminal version, and so when a cop comes out, he can give a fine of $500 the first time, the second time, and then the third time, it's a state jail felony, what it is now. So basically, I'm taking the criminal court side, which is a penal code, and I'm amending that to be 2 misdemeanors before the felony. And in doing so, this is the only tool that law enforcement has to enforce something. They won't come out anymore and be like, it's a civil matter. It's actually a criminal matter. It's a criminal matter now, it's just they don't enforce it because they don't want to jail a parent the first time they violate this court order because it could be by mistake or anything else. So
It's a family disturbance.
Right, so they don't want to give them a state jail felony, but with this, it gives a pattern of bad behavior, and it's perfect for the district attorney's office to actually hold this a parent accountable for this.
Could you imagine combining my policy, my program and his policy, how badly slammed that alienating parent would get financially, as well as with the other penalties? Okay, so moving on. This is my 3 strikes, which I've kind of explained. I'm not even gonna, no need to further go into it. You can take a screenshot. I don't wanna waste time on it. You can always email me. All this will be available on the PASG website, okay? And eventually we'll do they'll do extended courses on all of this. Just the one thing I will tell you is with my program, if they get through the 12 weeks, and on the 13th week, they start alienating, the program starts all over. If during the first 12 weeks they got a strike, if they do something on the 13th week, not only does the first strike continue, but the whole program starts all over, and now they got 2 strikes.
Can you go back to the last thing? I was gonna explain something.
Sorry.
So on the 3 strikes, this is the criminal version. Most people have every 1st, 3rd, and 5th weekend, and every Thursday, whether it's 2 hours or overnight. The first strike is Thursday. That's the first possession period. Friday, Saturday, Sunday is another possession period. That's the second strike. Literally by the following Thursday, this is taken care of by law enforcement, not family court, criminal court. That person is getting arrested for not adhering to the court order. There's no going to family court, having to retain an attorney for $3,000 to $5,000, wait weeks or months to get in there. That kid's already alienated. This is taken care of in a week. It's criminal court now, not anything to do with family court. Yes.
Is there any voice of the child in that?
No.
Thank you.
You know where Karen's
And there
coming
shouldn't
from.
be.
No.
Let me I'm not even gonna get into that.
All right, so we did this one. How these 2 complement each other, we just kind of mentioned that. Can you imagine? So let's say a judge orders my program, and now we're realizing there's a problem. The parent can go in on the policy of the legislative end and legal end. Post-appeal, judicial reassignment. Okay, so when you appeal on a case, and you win that appeal, it goes back to the same bloody judge you had in the first place. This is a problem.
One judge.
Because that judge has already filed against you and you've appealed. It needs to go to a new judge who can look at it from fresh, clean eyes. We can't say this enough. Training, education.
You know what, I want to touch on this for a minute, because I was able to change the laws in Texas, I was able to actually educate judges and lawyers on the law. And so they do what's called these CLE classes, continuing law education for judges and lawyers. So I was in front of about 200 lawyers and judges, educating them on why I had to make this law. After the session, I talked to a bunch of them. You would not believe how uneducated a lot of these professionals were. It blew my mind. It was almost like I knew more about what their job was to do than they did. At that point, I don't even know how to fix that one. But
It's scary.
and that's why when I make these laws, I make them no-brainers, very simple, short, concise, and it's a shall. That way there is no gray area, and they know what to do as soon as they read it.
So do you guys all understand? Look, this is the training we think the judiciary should have. Trauma informed, child development, child forensic questioning, domestic violence course, which are high conflict family, law enforcement, being your police, handling custody and interference cases, proper custody order enforcement, important support protocols for enforcement. Mental health, what do you need? You should have an advanced degree with relevant certifications. PASG conference, got your CEUs and your CLEs. Family attachment dynamics, so important because this is a family issue. If this was an intact family, would this stuff be allowed? No. Internal family systems, very important. And forensic evaluation experience.
Most important.
Our expertise. Child protection measures. This is important because the children are the ones who are getting harmed. They don't have the psychological ability to understand any of this. So, core protections, child not compelled to choose between the parents, no direct testimony in high conflict cases. Come on, that's a problem. Third, neutral valuations only. Only. Trauma informed support. Protection from weaponization in disputes. The weaponization is law enforcement filing of false allegations.
Yes.
Interview standards. We need to have standards when these people are interviewing the children because they're not getting it right. They're actually causing more harm. So, child-friendly environments. No, we're not gonna go sit in this little cubicle room where there's nothing. Open-ended questions. None of this. So, did your daddy hurt you? Oh yes, my mommy says my daddy hurt me. Video recording is required. Pre-approved question sets. No cross-examination permitted. Oh, you said your daddy hurt you? Are you sure? Confidentiality. These records and this work with the children has to be sealed. And transcripts need to be sealed. Protected identity unless necessary for a justice issue. And restricted media coverage. Why is this? Because these children are too young still. They shouldn't be in the news yet. They shouldn't be on the TV yet. Am I making sense here?
Yes.
Treatment and reunification. Mandatory programs. Family reunification, integration therapy. Our biggest issue, right, is that we keep getting these crap legislation blocking reunification. This is why legislation is so important. This is why we need the people to endorse and get the PA into the DSM and the ICD. Please make sure you hit the table out there with all the paperwork and the QR codes. Please put in your endorsement as to how not having PA in the DSM and ICD has affected you and your family, or your cases, or you as a professional. Monthly status conferences, clearly defining case goals. What are we doing here? Where is your ultimate goal going to be? What are you using to measure as a success? Post-treatment quarterly. You can't just say, oh, they're fixed. You need to have some follow-up here. Diagnostic tools. You've got at least 14 types of diagnostic tools, and I will tell you that when somebody does scientific research, they just don't do one to test it once. They test it 3 times to ensure that their results match. Use at least 3 tools if you're a clinician. You've got 5-factor model, you've got parental PARC, you've got the MMPI-2, not 1, this is the newer one which really helps. Clinical diagnoses. We have numerous clinical diagnoses, but if we can get it in the DSM and ICD, we're golden because now they can't rebut. You've got child psychological, we're gonna all agree it's child psychological abuse. Parent relational problems, child affected by parental relationships. Implementation timeline, and I'm kind of ripping through some of this, guys. Immediate upon enactment, post-appeal, stay of family court proceedings on custodial interference violations. If somebody's interfering, why are we letting this case keep going? We need to deal with the impediment first. So we have a timeline. You have 30 days, you have 45 days, you have 60 days. You know, we don't want 120 to do appeals and investigations need to be concluded within 3 months. Before, you know, we need finite endings. Robert's stuff hits it right away, but even with that, and we get the policy, they've been arrested, whatever had to be done, it's still being dragged on. No, these kids can't handle that. The human brain does not stop growing till age 25. It does not stop maturing to age 35. It is why our federal government does not allow children to vote till they're 18, smoke or drink till they're 21, or even rent a car till they're 25. They don't have it. You can't even be the president of the United States until you're 35, 36.
35.
Coordination and compliance. We need federal laws to match a lot of what we're doing. And in the states need to coordinate with the federal laws, cross-jurisdictional. We need to make sure laws are really the same from state to state, because a parent can pick up a kid and go, oh wait, in Michigan they don't have this. Oh, I'm moving to Michigan. Court requirements, annual reporting of parenting time divisions, separation of criminal and civil proceedings. Family court is a civil court. It should not be adjudicating on criminal matters.
due process protection for all parties. Because let's remember, the alienator is mentally ill, quantifies them as under the ADA to protect, technically. But the reality is, what is supposed to happen is that the agencies are supposed to provide them with support services. If that person doesn't take advantage of those support services, that is on that parent. Quality assurance, regular review of enforcement effectiveness is what we've put in place working. Standard protocols for consistency. Are we consistent in what we're doing here? And documented procedures and outcomes. Robert, let me know when you want to speak.
Can you explain 1038?
You know what, let me, well.
You do this one.
Well, I'm not gonna explain that one. What I was gonna tell you is, what I've been able to do and change in family court, is stop a lot of this process. Not just what she's, you already know all the legal loopholes. And so what I've done is, I've created enough bills for all 50 states, and you can go to my website, robertgarza.us. You can sign up to be an advocate, it's totally free, nobody ever gets charged for any of this. I'm doing this all out of my own pocket. And so on that, there's bills that are on there that would have helped anybody of what you went through in family court, whether it was 50-50 custody, false allegations, interference with child custody, your judge being bad, all this is in there. If there's parental alienating behaviors, all of these bills are on there, and you can pass them in your own states. I've made it very easy where it's a package bill. You just make a phone call or an email to your legislator. You send them that little 3-page report thing that I have, and it's an email to them, the background, and the bill itself. And basically, they put it through your legislator to pass it as a law.
You've learned it from the other side. That's what they've been doing.
Yeah.
Can you explain 1038?
1038, what's that?
He probably, if it's not up here, he don't.
18, chapter 18. You've
Oh,
got-
here, it's the federal law. It's not even, I don't even think I have, it's on the previous one, probably.
I have no idea.
It's a federal law, and basically providing you rights and due process. There's other pieces to this, and that's part of it. We have federal laws in place, they're supposed to protect you guys, but the states don't quite want to follow. So it becomes a problem. And 1038, which I don't know if I know it's been in the past, but something, here it is.
Yeah, so it's not a hammer.
Aligns with federal standards.
So it's not a whole new thing scaring people. It's a little sketch on
No,
top
it is there.
sketch on top of what already is.
Right, and where problem is, the states seem to like to ignore federal.
Go ahead, Lynn.
Yeah, I know you were talking about, when it's criminal, it shouldn't be in the family court, but Caden's law says that when a woman makes a DV complaint against a man, it has to be taken without any evidence. They
Right.
don't have to get evidence. So can you talk about the preponderance of evidence
Yes.
versus, yeah?
Yeah, so in family court, there's what's called preponderance of evidence. It's the lowest standard. It's 50% plus a feather. That's how much over. Basically, and that's why they're getting all these protective orders, restraining orders, because it's like, is it more believable than less believable? That's literally what these judges are looking at, and that's all 50 states. That's the lowest standard of evidence. They don't even have that standard of evidence in criminal court. This is a big issue, and that's why we're seeing a lot of these false allegations, and nobody's prosecuting for perjury, even though it's a felony. They're not following the law. And that's why I had to come up with the stuff that I have, because the judges had the opportunity to do the right thing, and they didn't do it. And because they didn't do it, I had to make something to right that wrong. And so,
Caden came to Philly.
yeah. So and just so you know, if there's bad legislation, you can repeal it. You can literally, the next session, get a team of people and say why this law is bad and show the statistics again, because maybe you didn't get there the first time, maybe they snuck it through or piggybacked on another bill. I've learned so much about legislation, it's not even funny. But I'm teaching a whole advocacy group of whoever wants to learn for free and pass these laws in your state, but also you have that, and once you pass good legislation in your state, your legislators look up to you. And they know that you pass good legislation. When you get up there to testify, they really listen to you like you're the professional, especially if you have initials behind your name, even more so. But you'll be able to repeal the bad laws in your state also. And so nobody teaches you that. I don't know anywhere I could go to learn this. I just had to learn it by trial and error. But I can teach it to you. But again, it's robertgarza.us, and just sign up to be an advocate.
And also for you guys, so you understand, 1 second, Lynn.
Wait, no,
You-
you 1 second. What is the level of proof in criminal court?
Yes, so there's preponderance of evidence, which is the lowest, clear and convincing, which is about 80%, a little bit more, and then 97% is beyond a reasonable doubt. To take someone's parental right away, you have to have clear and convincing evidence. Now, my last bill that I wrote heightens that standard to clear and convincing. And if you think about it, it stops the false allegations because the judge is gonna say, okay, prove it. They get on the stand and just say whatever they want and it's perjury, the judge is gonna say, prove it. At that point, you heighten that standard, but I've talked, again, that one's coming, I'm trying to still work some things out on it, because when you heighten that standard, you also heighten the standard for someone that really is being harmed to meet that next threshold. And that's what I never wanna do. And I will never pass a bill, if it's going to hurt more than it fixes.
So what about the TVs that are tried in the family courts? You know, they go to criminal and then they refer back to the family.
Yeah, so I have a fix for that. And so if someone pulls you into a criminal court and gets whatever to come weaponize it in the family court, one of my bills actually has that you have to be prosecuted for it.
Not
You have to-
prosecuted, convicted.
You have to be convicted, sorry. You have to be convicted and found guilty of it for them to bring it into a family law court. And like, let's just say drunk driving. Even if you're arrested for it, in my bill, it actually has that you can, but it's a separate procedure to see if you can get it into your family case. So you have to have a pretrial for it before you can bring it into any kind of evidence in that and weaponize it, so.
I just want you guys to all know, you can go out to your state's website, legislative office buildings. You can sign up to receive notifications on the bills that are out there. You can put in keywords such as parental alienation or domestic violence, and any bill that is coming that has those keywords in it will be sent an email to you for you to follow, or you to if you want to, go to your legislators and sit there and testify. All right?
You don't have to go anywhere. You are a constituent of the jurisdiction where you happen to
Right, but if you don't know that the bill exists, go sign up with your legislative offices to be notified when these bills are coming up with the keywords that you put in.
They'd love to help you.
So financial, we've already discussed this. When we did the consortium, we had the same issues that Robert was concerned about. If someone's gonna interfere, hello, you should be paying for the treatment costs for the psychological damages. False accusers liable for therapy costs. Come on, this shouldn't be legal fees, supervised visits. Grant programs for indigent applicants needs to be developed because so many can't afford this. Recovery of legal expenses and associated costs. Robert, he came up with the bills for this stuff. I mean, we did some, but his are much more fine-tuned, to the point, in one page. Justice for targeted parents, reimbursement of fees, damages available, and costs. Child support, his dual calculation, immunity provisions. Expert witnesses need to be protected, we're not. Treatment professionals, qualified professionals, conducting evaluations. All of this is necessary. Complementary damages for professional harm, punitive damages for egregious conduct, reputational damages for our experts, loss of employment and compensation. Safeguards and due process. We've kind of touched on this a little bit. Protection for all parties. Even the alienated parent ends up getting sucked into stuff. They get sucked into their attorney telling them, oh, you gotta file this, then they commit perjury and now they're in trouble. Protection against retaliatory acts, regular status review requirements, standard evidence preservation, because it's amazing how evidence just disappears. Genuine victim protections to a balanced investigation. Clear distinct between the legitimate and malicious claims. This is so important because the malicious claims gum up the works for even the true victims of abuse. Protection from genuine harm is important. We all recognize there is true domestic violence and physical and sexual abuse. We need to make sure that the person evaluating is properly trained to know when it's a lie and when it isn't.
You know, I wanna interrupt you for a second. So I help people all the time with their cases and everything else, because I've been through this. I'm an expert at false allegations now. And I talk to attorneys all over the country. This is a massive problem. So there's legislation, well, not even legislation, there's grants out there like VAWA, and they pay attorneys to represent people that have been through domestic violence. I had a woman that called, and she was like, hey, you know, can you help me here? And I was like, you know, and then she calls back and says, hey, I have an attorney now. And I'm like, well, I thought you know, I sent you a couple of people, but I know you didn't have much funds. She was like, yeah. She was like, I called this law firm, and they said that they do domestic violence and it's free. And she was like, oh, well, there was no domestic violence in my case. And they're like, well, did your husband ever raise his hand at you? She was like, no. Well, did he ever scream at you or raise his voice at you? And she was like, yeah. She was like, okay, we can help you. Oh my gosh. She got a free lawyer because he raised his voice. She was like, yeah, but I raised mine at him too. She was like, everybody argues. She was like, no. We didn't hear that.
Yeah.
We heard that you said, and guess what? That goes on the stats that men are abusive. And she just got a paid free attorney. That is a scam that I don't even know how to solve that one.
That comes down to, we need to make sure attorneys are held accountable for when they can inculcate a false allegation with their clients.
Well, did you talk about the woman, the VAWA Act?
Wow.
Did you talk about that? Because
Well,
they're
we-
the ones who provide.
Right, that's part of the problem. The VAWA will not provide any support to anybody who's dealing with parental alienation.
But they fund the domestic
the
violence
violence.
program.
So I don't know if you guys, those of you not in the United States, it's the Violence Against Women's Act. And it is the most dirtiest act because it doesn't help, it's only for women and children. Right, I hear Ken over here, money.
The other thing with violence against women, so if someone is not from this country and you have violence against you, supposedly violence, and you're getting divorced, now all of a sudden you can stay in the country if there's violence against you. And so because your husband's divorcing you, now you can just get your citizenship just by saying you had violence used against you.
So you have
If
appeal
you're a
rights.
woman.
Don't get me wrong.
If you're not
A
a
woman.
man, if you're not a man. yeah.
Don't get me wrong, you have appeal rights, but you really need to know how to do an appeal. You cannot appeal something that was not in the original case. Please remember that. You cannot appeal something that was not in the original case. But we need a standard appeal process maintained. Judicial review of enforcement of decisions. Documented reason for any deviation from the standard procedures. Because these judges just like, oh, you know what, I've got discretionary, I'm just gonna end your parental rights. No, it doesn't work that way. What did Kevin Hickey say? We need your orders to say shall. We need the legislation to say shall, not can, shall, important word. Key definitions and summaries equals shared parenting. I think we kind of know what that is. You share 50-50 or as close to it as is reasonably possible. Custodial interference, we all know. In the US, this is a felony. In Canada, it may not be called that, it may be called something else, but it's technically kidnapping. False allegations, malicious prosecution, intentional infliction of emotional harm. These are all various terms.
I'm gonna interrupt again, because I just thought of something. So custodial interference, think about this. It's a state jail felony in most states, the first time you do this. That's how it's handled in criminal court, which has the higher standard. Imagine that you can go to family court and they're just like, don't do it again. You just told a person that committed a state jail felony to like, don't do it again. Are you kidding me?
When I was testifying in 2014, and I told them about my 3 strikes problem, I first told them about my husband's case. And I said to them, we had 6 court orders. And the judge said, bad girl, there's a new court order. Bad girl, I literally went like this. What? Bad girl. I had to wake them up because they weren't recognizing what was kind of going on in these courts. The false allegations, qualified professionals. We can't say this enough. You can't have somebody on a case. I got a supervision case. The girl that's doing the therapy for the mother who's the alienator has no degree, no license. She's an associate license, working on her license. She should not be doing this therapy for this mother. In fact, her court order says it must be somebody who has a PhD or higher. Best interest of the child. There is a general understanding what this is. We seem to be fighting over what this is. At some states, some countries, they have a definite definition. Basically, it's about what is going to be the best alternative, the best situation to create a healthy environment for a child and their life. Robert, anything?
No, it's fine. Go back to best interest of the child. So best interest of the child, that's actually defined in the federal code. A lot of people don't know that. It's actually in Title 4E. There has to be death or very abusive harm to a child for you to take a parental right away. In the federal code, they borrowed the term, but they didn't bring over the definition in family court, and that's where the disconnect is.
Yep.
You can look at it in the federal code, it's very well written. Go ahead.
But go ahead.
I'm up against, in New Brunswick, I'm up against a law that doesn't seem to exist anywhere else, and it's the child's view. And they go by it literally, and it's allowed them to isolate my child for 6 years, can't see her at all, and they've turned her against me, because it's the child's view, right?
In his case, just so you understand, it is not the mother doing the alienation, it is actually an agency. The mother has been deemed unfit, and it's Child Protective Services that has stepped in. So understand, parental alienation can occur through an agency as well.
All right, so I looked it up. I actually wrote a thing to our legislators about it. And the federal government has established specific guidelines for acting in the best interest of the child under Social Security Act, Title 4E, and Child Abuse Prevention Treatment Act, which is CAPTCHA, only if a parent has committed murder or serious bodily injury against a child. This aligns with CAPTCHA's definition of child abuse, which also includes acts or failures to act resulting in death, serious harm, or imminent risk of serious harm is the only way you can take a parental right away. That is in our federal code. They took the term, and that's why they use it as a wild card in family court, and they didn't define it. Because if they did, they wouldn't be able to do what they do now.
This is why I tell you in the United States, they are not supposed to be able to take your parental rights or unless they have had an evidentiary hearing that has deemed you as an unfit parent. Expected outcomes for children. If we could get some of these legislations passed, reduce psychological trauma from custody proceedings. Custody proceedings are one of the most traumatic things because he keeps coming home. And the one parent is telling the kids, and the kids are being torn. Psychological splitting. We are seeing a massive number of kids dealing with high conflict custody cases who have gender identity issues because of it. Protection from manipulation and coercive control. Better long-term emotional and social development. For the parents, what are we going to get? Clear standards and expectations. Protection from false allegations, which is what breeds these problems. Equal opportunity for meaningful parent-child relationships, fair judicial processes. Something that is equal across the board. For the courts, consistent evidence-based decision-making. They're going to have something to work from. Reduce repeated litigation. Clear enforcement and mechanisms to enforce. Improved case management efficiency. And guess what? Reduction in the family court cost. But guess what? Most attorneys don't want to happen. Because this is the largest money-making industry in the law, in law.
So, for y'all that are not from the US, family courts are a $60 billion industry. That is more than all other courts combined. Criminal courts and all other courts. That is massive. Now think about this. That's not a bunch of deadbeat parents that don't want their kids. Deadbeat parents don't show up. This is literally parents fighting for their children and their a bond with their children. This has to be solved. The way that the court is set up right now is weaponized against parents and children. With these things fixed, it will tweak the system to where it works for the people and it's by the people.
And it's helping the kids. What is our end goal here? To protect our kids from having to go through this intense psychological trauma. Monitoring review. This came from my legislative conference, basically ongoing assessments, clinical, we've mentioned this many times. Annual reporting, regular review of enforcement, periodic updates, continuous professional education, ever so important. Data collection, we need the collection of the data to show that what we're doing here is really working. And if it isn't, well, what do we need to do to fix it? Case outcome tracking, how are these cases tracking? Compliance, are we in compliance, or do we need to monitor this? Success rate measurements. How much success are we getting? Is there a fall in one area of success? Do we need to look at that and address it and do some research on it? Quality, and then I'm gonna let you, quality improvement. Regular statute review and updates. Best practices. Training programs. Stakeholder feedback incorporation. Your stakeholders in all this. Robert?
Yeah, is there any questions? And the reason I'm saying this is because I just saw what time it was. I have a documentary to go film, but I can take some questions if you have some, and then she can continue with whatever. Does anybody have any?
These are your additional reforms. I'm just going to flip. I think we've discussed all of these. Okay? Conclusion and next steps. Legislative package benefits. Basically, we have the comprehensive child protection framework, accountability for system abuse. Because this is a lot of what we're dealing with abuse. They're evidence-based. Where's the evidence? You didn't have evidence? Then how are you cleaning this? Protection from fundamental parent relationships. Professional training programs. Roberts adds critical procedural reforms and accountability measures, including judicial efficiency requirements, courtroom transparency, appellate rights, and enhanced access to justice. Implementation requires legislative adoption in targeted jurisdictions, court system procedural updates. And our final, we're calling you guys to action. We need you guys to get into your states, into your countries, talk to your legislators, know that there is a proper way to approach a legislator. I don't want you going in there and you're in a pair of torn jeans with a ripped t-shirt. No, please come in presentable. Please speak appropriately. Don't get me wrong, do I curse? Of course I do. Do I sometimes try to apologize before I say my curse word? I try it. But be professional diplomatic. Robert?
Well, I think that watch Robert on video and see how you cover all the points so there's no room for anyone to argue.
Agreed.
And emulate that.
You have to say things in such a way that it can't be disputed. And that's the way I try to write my legislation also. I don't write it for one gender or the other. It is for all parents and all children in mind. And so that's why I think I've gotten so far with what I've been doing, is because I don't take it personally what they did to me. And when I'm talking in front of all these lawyers and judges, talk about restraint, because I am in the middle of the people that did this to me. And to be able to tell them how to fix it rather than take it out on them is a lot. And so you can see how far, that someone's come that will be able to do that. And so I hope that my legislation helps you all, if you're going through this, help you see that there is a way to get back at the system, because you're going to change it for the better. And imagine even if your kids are alienated, that you tell them that you had to change the law because of what you went through, so no one else has to go through that. That is a massive shift in the way of your thinking. You're going to turn your pain into purpose. And that is the whole point to this. That's why I didn't go do this myself. I could call 100 legislators in all 50 states, one House rep, one whatever. I didn't do that because I want to teach people to be able to do this for generations to come, and this is turning your pain into purpose. I didn't name these laws after me, after my children, anything like that. They're named appropriately.
Also, I think by talking to your children and telling them, hey, this is what I did, you're teaching your child critical thinking, as well as you can stand up for things that you can fight for, that make sense, that where you've been harmed. Don't be afraid to speak up when you've been harmed and you need to talk. I brought up, this was for my slide, on my information, and then because I actually own 2 nonprofits, Past Intervention, but I put this one through PA Consortium, which is the umbrella organization for all organizations. It was begun by Dr. Jennifer Harmon, and then when she was unable to continue, it was picked up by Philip Hendricks of the PASG, and myself, and a couple of others who have been running that. If any of you are 1960s, you might remember this as being war is not healthy for children and other living things. I changed it, obviously.
Make love, not war. 60s.
And this is Robert.
Yeah, so I was going to tell you, so I'm also the vice president for National Family Justice, and we're doing really good things on family court stuff and to do with veterans. Also, I have so many titles. The biggest one is go to robertgarza.us, become an advocate. I'm also a Texans for Judicial Accountability and Americans for Judicial Accountability, and what we're doing there is we're changing the laws for the judges and holding them more accountable and putting citizens on the judiciary committees that hold the judges accountable, because those committees are made up of just lawyers and judges, which
Conflict of interest.
huge conflict. And so by putting more citizens on those boards, it changes and it just holds them more accountable.
Ken,
Go
and
ahead.
then I will take Vernon.
Just going back to Caden's Law, K-A-Y, Caden's Law in Pennsylvania. I'm a custody evaluator in Pennsylvania. Caden's Law, capital S for safety, is the word safety, which changed my way of doing work required in your legislation, the word safety itself.
So adding that in, he's saying the word safety into some of the legislation, saying this is a safety measure. This is to provide a safety net.
All of it's safety. I mean,
He's saying use the word.
We have statutory factors in Pennsylvania, as many states. It changed our statutory requirements. We as evaluators now have to add one more factor, safety.
Oh, got it.
And judges are required, if they're, get reversal appeal if they don't do that.
Okay, well, we'll
Vernon.
put it in my stuff
Highly weighted.
for your state.
I'll just introduce a concept or an idea that would improve the system. Years ago, I came up with a term, it was called a Community Justice Committee. Okay, the concept around that is to gradually move the judges out where you have a panel of citizens, okay, who like a jury. They might get paid by the government, but they're not gonna get paid like in Canada. The judges get paid about $400,000 a year, plus all kinds of benefits. So you would have a panel of people, maybe 6 people, 3 people, whatever, and they would adjudicate. They don't need a courthouse with all that security and people getting in, like in Canada, we've got security guards, we've got scanners, people going into the courthouses. These hearings could be held in a commercial, like a hotel, which some hotels do. You have a meeting room, and you could hear a case, members of the public could attend, and you would have the people from the real people, which is what the concept of a jury is supposed to do. But if you had a citizens committee that would adjudicate a lot of these cases, it could probably save a lot of money, and it would improve respect for the outcome. So that's just an idea.
I see what you're saying.
Community Justice Committee to make decisions based on family law
And
cases.
the 8 members before the father could choose those people.
You go.
Mother would
I'm
choose
fine.
them before.
Just an idea.
Robert, I want to thank Robert for being here today.